Good day. Welcome to another of the CAEF Web Talk series, Anti-Semitism in the Age of Wokeism. I'm Andrea Spindle, Executive Director of the Canadian Anti-Semitism Education Foundation, and today's expert presentation is on employment law and combating anti-Semitism with special guest Howard Levitt. CAEF is a registered charitable organization focused on combating anti-Zionism, which is today's most prevalent form of anti-Semitism, whether in the media, academia, or in political settings. Anti-Semitism is also prominent in unions, increasingly in some professional organizations, sports clubs, and even corporate settings. Our tools for countering it, while not well-resourced, are quite simple. Truth over lies, history over narratives, building allyship with other ethnic and faith communities, and fostering Zionist pride and resilience. CAEF relies on volunteers and builds collaborative relationships in all our projects, including in organizing and delivering these webinars. Today's webinar is co-sponsored by the following NGOs: the Lawfare Project, the Mattathias Project, End Jew Hatred Canada, Beth Torah Congregation, Stand With Us Canada, the Canadian Institute for Jewish Research, European Lawyers for Israel, Americans for Peace and Tolerance, the Jewish Leadership Project, the Israel Committee of Sonoma County, Combat Anti-Semitism Movement, Israel Action Committee of the East Bay, the Lodger Center Congregation, Adath Israel Congregation, International Christian Embassy Jerusalem in Canada, Beth Tikva Congregation, Israel Activist Calendar, Cherut Canada, the Coalition of Hindus of North America, and New Hampshire for Israel. You can see it's very broad. We are definitely reaching into many communities. And I also thank Levitt Sheikh, LLP. Please consider making a donation to assist with costs that include creating educational resource materials, all of which are available on our website, research projects such as our study of anti-Semitism in social work education, organizing advocacy events, and producing webinars. Donations online can be made at www.caef.ca or in the US through the Lawfare Project. It's now my pleasure to introduce a noted Canadian expert on employment law, whose weekly column on legal situations in the workplace has in recent months dealt with anti-Semitism in the workplace and on campus. Howard Levitt has addressed the topic of the chilling effect of bias in the workplace and the sensational story of 74 law students at the Toronto Metropolitan University signing a letter of support for Hamas after October 7th. Howard Levitt has appeared as lead counsel in more employment cases at the Supreme Court of Canada and most in provincial courts of appeal than any other lawyer in Canadian history. He has been lead counsel in thousands of employment law cases. He is regularly cited in, He's regularly cited for his practice, and he chairs the employment law and labor law conferences across Canada, including those of the Ontario Law Society for its first 10 years. Howard is the most widely quoted authority. He writes a twice-weekly column in the Financial Post, has weekly radio appearances discussing employment law, and is the author of one of Canada's leading dismissal textbooks entitled The Law of Dismissal in Canada. He has authored 5 other textbooks and is editor-in-chief of the National Law Report. Howard is the labor lawyer and employment lawyer for many of Canada's largest corporations and acts as chief spokesperson for numerous collective bargaining negotiations in a variety of industries. He's also a lobbyist for several clients regarding labor legislation at the federal and provincial levels. He has worked with several Liberal politicians and several Tories, and is recipient of the Governor-General's Award for Community Service and Citizenship. In May 2023, he was elected as a bencher for the Law Society of Ontario. Before I turn the floor over to Howard, may I remind everyone watching to please use the Q&A function on your screen to leave your questions, and not the chat. And in the chat, please tell us where you live, where you're listening in from, and you may post comments, but please be respectful. Howard, welcome.
Well, thank you so much, Andrea. I'm going to speak for about half an hour, and then I'll take whatever questions you have. What most people aren't aware, even before the tragic events of 3 months ago, is that in 2021, according to Statistics Canada, a Canadian Jew was 36 more times more likely to be the victim of a police-reported hate crime than an Indigenous Canadian, 18 times more likely than a Muslim, and 3.5 times more likely than a Black Canadian. Jewish Canadians have been, in that context, since 2021, been complaining to me for years that their own victimhood hasn't been recognized as experience anti-Semitism in the workplace, and particularly in DEI conferences and seminars. Now, I've given you what I think are shocking statistics, at least shocking to most, shocking to me when I read them. But the numbers have exacerbated considerably over the last 3 months when anti-Semitic hate crimes have escalated wildly and disproportionately. Far more, I might say, than against Muslims, although our Prime Minister's liberal cohorts have insisted every time there's an anti-Semitic hate crime to condemn anti-Semitism and Islamophobia, which really has nothing to do with the instance in question. I guess reflexively attempting to attract the Muslim vote, which is much larger than the Jewish vote and seems to be impacting at least on a liberal party. Now, we've heard about some of the issues with DEI over the last few years. The term white privilege was aggressively used to inculcate the concept of original sin into every Caucasian idiotic enough to believe it, such that we have to apologize for success and relinquish the product of our hard work to others. It reached its apotheosis, its height. For those who have heard about this, teacher Richard Biltzko committed suicide. Why did that happen? Because he was a teacher who had been in Buffalo teaching, was a teacher in the GTA. He attended one of these inclusivity seminars led by a DEI instructor, Kike Ojo Thompson. And she said, Canadians are more racist than Americans. He said, look, I taught in Buffalo. That's simply not true. And she responded with, you and your whiteness think you can tell me what's going on with Black people, and then proceeded to castigate him for the rest of that session and the following sessions. And his teachers union didn't support him. He launched a lawsuit. He filed a workers' compensation claim because he was so distressed he couldn't work. They found, after a hearing, that he was toxically abused and was entitled to damages, and made really quite pejorative comments about the instructor and the teachers union. And finally, he killed himself. Couldn't take the stress. That was DEI. What should DEI really be about? Diversity, equity, and inclusion. Well, I'm going to quote Bill Ackman. And you might know Bill Ackman as the head of one of the largest hedge funds in the US. He's also more recently the person probably most significantly involved in bringing down, happily, the regime of the anti-Semitic president of Harvard, Miss Gay. And he, interestingly, when all those Harvard students signed that petition, these anti-Semitic petitions right after the events, the Gaza pogrom, he said, I want the names of all the students who signed those petitions, because I want to make sure they go on a never hire list. And got a bunch of other business leaders to say, we want them on our not never hire list too. And interestingly, all of those students, or many of them, suddenly said, oh, it was a mistake. I didn't know what I was signing. Take my name off. The same as the TMU students who tried to remove their social media profiles when I and some others published they should be on never hire lists at law firms in this country, including my own. So Bill Ackman, back to the point, wrote a column recently, and he said the following. in discussing the issue at Harvard. I came to understand that diversity, equity, inclusion was not what I had naively thought those words meant. I always believed that diversity is an important feature of any successful organization. But by diversity, I mean diversity in its broadest form, diversity of viewpoints, politics, ethnicity, race, age, religion, experience, socioeconomic background, sexual identity, gender, one's upbringing, and more. What I learned, though, was that DEI was not about diversity in its purest form, but a political advocacy movement on behalf of certain groups deemed oppressed under DEI's own methodology. As Barton Swain recently wrote in a Wall Street Journal article entitled How Anti-Racism Becomes Anti-Semitism, quote, at each stage of this ugly evolution, left-wing commentators and politicians became more comfortable with what looked and sounded like straight-up racial bigotry. He continued that the target of their hate was white people, made the rhetoric appear harmless, but it wasn't harmless, as anybody might have foreseen. Calling Jews white deprived them of any cover as a racial minority and classified them as persecutors and exploiters. Israeli journalist Howard Levitt addressed the dynamics of anti-Semitism in Commentary magazine, and without quoting her, I'll quote instead, actually, to the same effect, Bernard-Henri Lévy, who spoke at APAC at a session I attended a few years ago, the French philosopher, to the same point. Anti-Semitism has morphed over the years into whatever, over the decades, over the centuries, into whatever form was politically palatable. And its current incarnation over the last 2 or 3 decades is anti-Zionism. But make no mistake, its pernicious impact and ultimate motives is rank anti-Semitism. Now, I and others have been saying that for some years and been dismissed by many. But the evidence is now rather undeniable, because after the pogrom at the Gaza border and before Israel's counterattack, celebrations sprang out throughout this city and virtually every significant city in the world. And quite apart from the street demonstrations and celebrations of Jews being raped, tortured, massacred, beheaded, thrown into ovens, there are similar comments in social media, which is why I've taken the position publicly and repeatedly, both in the National Post and a tweet that my friend Jordan Peterson sent out, that anybody who's managerial or public facing or client facing should be fired for cause if they attend one of these hate rallies or spew anti-Semitic rhetoric in their social media posts. And why do I say that beyond the politics? I say it because in employment law in Canada, if you do things to damage the brand of the company you work for, and virtually every company in this country has, excuse me, policies prohibiting racism and anti-Semitism, and they're required to endear to it law because of the Human Rights Code, it's damaging to that brand. An employer could fire that employee for cause. So what do you do? What's your recourse? What are your options if you suffer from anti-Semitism in your particular workplace? Firstly, and you can do this whether you're non-union or in a union, you can file a complaint under human rights legislation. My firm has filed the complaint against CUPE, and its president before the Federal Human Rights Commission, the Ontario Human Rights Commission. And we're aggressively pursuing that case. And it's interesting that the president of CUPE is gay, which is fair enough, except supporting Hamas and being gay seemed to be a little contradistinct. If he were in Gaza, he wouldn't last a day. In addition to human rights, you can resign and file a constructive dismissal case, meaning that the employer has made conditions of work intolerable for you, objectively. Now, before you do that, you should at least write a note or a letter complaining and protesting. Obviously, if the HR person or your manager is the person who is the anti-Semite, that's not who you write to, but to someone in the organization more senior than that person. And if they don't rectify it and say this, you can't stay in the organization anymore and claim constructive dismissal. Then there's the action of negligence, which is actually far more powerful in terms of compensation than constructive dismissal, which is only measured by a certain number of months, up to 24 or 27-month severance pay as a maximum. Negligence can be damages for years based on the company not taking appropriate action to end the conduct, the anti-Semitic conduct in question. Then there's the Occupational Health and Safety Act. That doesn't get you any money, but they have anti-harassment provisions in the act and can levy fines and terrible publicity against the employer in question. And there's also the company's own policies. Every policy has mission statements or anti-harassment procedures or simple letters or notes written by the employer from time to time about the environment they intend to cultivate in the workforce. And anti-Semitic hatred is obviously contrary to any mission statement I've ever seen, or certainly any anti-harassment policy. And those mission statements, sometimes piously written without even really thinking it through, become legal contracts between the employer and all of the employees, contracts you can sue upon. So you have an action for breach of contract. Finally, there's some other actions. The tort of intimidation. Torts are civil wrongs that you can sue for. Intimidation, intentional infliction of nervous suffering, conspiracy to injure, and defamation if things are said negatively about you that are disparaging. Now, sometimes you sue because you have a little recourse. But my view is that if you're facing racism in your workplace and you have the requisite stamina, consider these legal actions not merely to get damages or severance pay or payments of one form or another for yourself, but to make a point politically to force the companies and unions to change their culture and to publicly humiliate them so they stop. Now, what if you're unionized? Unfortunately, your actions are much more limited. Unions are determined by statute and by the Labor Relations Board to be inexpert bodies, just lay people, however sophisticated some of them might actually be. They're entitled to make mistakes. They're entitled to not make the best decisions. And when I say entitled, I mean there's no recourse if they do. They're entitled to pick certain grievances and not other grievances to put them forward to arbitration because they have limited resources ultimately and they can choose where they put their money. What they're required to do is at least put their mind to it. And the only recourse, if you file a grievance, this is what you have to do if you're in a union, and the union refuses to take the case, is to take the union to the Labor Relations Board based on what's called a duty of fair representation application. Their success rate of duty of fair representation applications are about 1%. I think in a case like this, it would be much higher because unions can do what they want effectively unless they act arbitrarily, which means they don't put their mind to it, discriminatorily, or in bad faith. But if you've got good evidence the union itself is anti-Semitic, you certainly have powerful recourse before the Labor Relations Board in arguing they made their decision discriminatorily and or in bad faith. So you might have a better prospect than the customary 1%, but it's tough. Human rights applies, of course, to unionized employees too. And there's lobbying. If you're in a governmental union, lobby the government to make sure in the next round of collective bargaining, the union accepts clauses that fight racism and protect you in your workplace. What if you don't work for a governmental organization where you can't lobby, but you work for a company that is sympathetic to your point of view, not to the anti-Semitic union? Well, then lobby your employer to come to the table of bargaining in the next session and put in the appropriate clauses. Of course, you can start by writing letters that you hope the union will find embarrassing to the union, requiring them to answer. And when they don't answer, as they won't, then plaster it over social media. Go to reporters of newspapers and have them broadcast what's happened with copies of your letters and telling them what's happened. And the last two recourses are the best, but the most difficult. And they are coming up with numbers at the next union election meeting and voting the scoundrels out and voting another slate in their stead as the next leader of the union. And the last and best is decertifying the union entirely, which requires in Ontario signing up 40% of the members of the bargaining unit, and then a vote will be called. So those are the basic legal recourse. What if an employer takes a stand you find is hostile to you on human rights grounds? Well, you can go to the Human Rights Tribunal. You can file whatever internal grievance procedures exist. If you're in a union, there will be a grievance procedure. For a non-union, there may be, saying you view the policy or practice or behavior or conduct or edicts or rules or behavior to be offensive to your ethnic or racial group and lobby to change the policy. And if the policy or behavior creates an atmosphere of the workplace impacting on your working life as a Jew, you have a right to file a human rights or a constructive dismissal complaint, which can be combined in one civil action in Ontario. What if the union, what if the union or the employer calls for workplace investigation? Sometimes they're going to respond to a complaint of racism by starting a workplace investigation. Sometimes do it honestly, not knowing what happened, and genuinely wanting to get to the bottom of it and maybe help you out if your complaint's legitimate. That's not usually the case. Usually it's the delay tactic, giving them a chance to prepare a defense, prepare a lobbying campaign, hire a good PR firm like Navigator to assist them in crisis management and information control, get a public relations plan in advance of any statement of claim being issued or any public hearing. If it's the latter, in other words, if it's not being done in good faith, and you probably know which is the case, then don't permit them the time. Well, the other thing you want is to investigate you, get your side of the story, and be better prepared and get potentially inconsistent statements for later on to get a free examination for discovery if you know the court system, you're getting the right to examine them in response. If that's what's going on, I would quickly file your claim, issue your press release, or do whatever else you wish to do before you give them a chance to group and contest you. Don't wait. Also investigate the background of the so-called investigator they've chosen to see if that person's expressed an opinion on the subject. I remember a case 2 or 3 years ago in the Toronto area where there was an anti-Semitic issue and the investigator had historically tweeted indicating a bias. So check their background. Now, most investigators, in my view, are just hired guns, and my experience, not just my view, or my view and viewed by experience, looking to be reappointed for further lucrative investigations. Investigations requires little legal knowledge and skill. And by the way, the reports have no weight whatsoever with the courts, because judges have to hear the evidence themselves. They can't rely on what an investigator found in their interview. That's called hearsay. It's not even admissible. So it's of no weight whatsoever. But if you get a negative investigation report, respond immediately in writing, noting any bias of the investigator, the historic financial involvement with that employer, witnesses whose names you proposed that they failed to interview, misapprehensions of the facts or the law, the inherent improbabilities of their conclusions, and the fact they disregarded the evidence of those witnesses whose evidence they didn't even list. An employment lawyer might assist you with that rebuttal. The police have not been great. Switching to criminal law for a moment. They allowed a horrible mass protest day in and day out in the heart of the Jewish community at Wilson and Avenue Road, only stopping it after there was massive reaction, both from our community and publicly. For days and days and days, it went on with 9 synagogues within 1 kilometer in a purely residential area, not a public square, with lots of Holocaust survivors in the area and lots of Jewish residents who took the mezuzahs off and stayed in their house for personal protection. The fact that they belatedly stopped it simply isn't good enough. They had the incident of the Islamist terrorist in the Eaton Center threatening to put some passerby 6 feet under, right in front of the police, and did nothing. And the police were asked, they said, well, they weren't threatening us. They're threatening a member of the public. I mean, I always thought the police are there to protect the public, not to protect themselves, but that was actually their idiotic response. So I give your head a shake. But they did charge what these Toronto Stars call the Indigo 11, who sprayed red paint signifying blood and put posters of Heather Reisman up in front of the Indigo shop at the Manulife Center. They arrested them and then a week later filed criminal harassment charges against them, which is wonderful. Potentially 10 years in jail. And there's been massive resistance to that and protests, largely from the academic community and the left community generally, because most of these protesters were, not surprisingly, academics and students, which is where most of the rot has come from over the last few decades. Our community should use its levers to lobby City Hall, lobby the provincial government, lobby those members of the police board, to make sure that lobby the chief, Myron Demko, who's a good guy, but hasn't been tough enough yet, to not drop those charges and to vigorously lay further charges going forward. So people say, what can the police do? This isn't criminal conduct. Well, those who say that don't know what they're talking about. Blocking roadways, as they did at Wilson and Avenue Road, is prohibited by the criminal code. If they attend private property, as they did at Indigo at the Manulife Center, they can be charged with trespass. They can be charged with criminal harassment. They can be charged with nuisance. There's lots of criminal law remedies. See if there's any other. There's a criminal code prohibition against uttering threats, and the threats can be either private property or bodily harm. Incitement of hate is another criminal offense. As they say, criminal mischief and criminal harassment. So there's all of these offenses have been applicable to what we've already seen in the streets of Toronto and other Canadian cities. and the police largely have done nothing. And we have to do what we can as a community to lobby them to do far more. What I would like to see happen is all of these people attending these hate rallies be identified, and everyone issuing racist anti-Semitism on social media be identified, and social media profiles be created. That's happening through an organization in the United States called Canary Mission, and they should be brought into Canada, which they've expressed, talking to them, they're expressed an interest in doing that. We get the requisite funding, and those will be on their social media profiles forever. So they apply for a job, employer will know what they did, just like the 74 students at TMU. And just as the 74 students at TMU and the students at Harvard, when Bill Ackman wanted their names, we'll watch how quickly that those protests dwindle in numbers. So those are my thoughts on the law and anti-Semitism in Canada right now. What we can do, what we have done, what we should do, what you can do. Happy to take any questions you have.
Thank you, Howard. I'm going to start with a question that came to me even before we began this webinar, and I think you may anticipate it. Your company is now called Levitt Sheikh, and your partner, and I guess as she's a senior person, Community Sheikh, has posted on her private social media several comments we would judge to be anti-Semitic, in that she's made critical comments about several people who we see as perhaps strong supporters of Israel, two politicians in particular. And I haven't read all of the postings, but I gather there have been several where she's taken a position that she supports the Muslims and Israel's a bad player. Can you comment on how that affects you, your company, and your relationship with your partner?
Well, it affects me because you asked me this question right now. That's affecting me. No, I've had over the last 48 hours, many people writing to me about it, actually. And she's agreed to take down those two posts in question that we talked about yesterday. She's agreed to be more moderate and to think about her posts rather than rip them off as emotion takes her going forward. It's created a difficult situation. I mean, she's a partner, she's not an employee. Let's start with that. The avenues are obviously, it's very different. And we've had an article written about us in the Toronto Star about a month ago, talking about how we have such different views, are both public advocates for our cause, and yet we get along in the workplace. But I agree with you, a couple of those posts were not moderate, and she's acknowledged that and taken them down.
Well, I'm happy to hear that. But I think it then leads to an interesting question, because when you talk about anti-Semitism in the workplace, we are often talking about somebody who is either an employee or the supervisor, but a lot of the anti-Semitism people experience will be at the collegial level, right? Your colleague on your team says something untoward or posts something. And so you're talking with somebody who's your equal as well. Can you talk about the conversations and the suggestions you have for people who are in a team? They don't want to leave their job. They don't know how to deal with that. And the other people might hear it or might not hear it, but it's not about a supervisor that's giving them difficulty. It's a colleague. Can you make comments about what to do?
There's a bit of a difference between someone posting things that they're upset by and someone saying things in the workplace to them that are offensive. Let's take with the latter one first, because that's the easier one. If someone is making a hateful comment in the workplace, and by the way, when I say the workplace is very broad. If a company Christmas party, that's the workplace. If someone says something about you on social media and they do it at night, that's the workplace. The workplace is expanded to be every interaction you have with your work, not a physical presence, which I guess makes sense in the era of COVID when people are working from home in any event. So workplace broadly defined. Then you've got a human rights complaint. Now, the first thing you do is you contact HR and or the manager and say, this person is creating a toxic poison work environment for me. I want that dealt with, either by firing them or by getting them to stop. If they don't get it to stop, you then have an action against the employer as well as against the employee in question. And the human rights complaint actually, or court case, would be against both. And by the way, I would advise you, anyone listening, to make sure the complaint is against both the company and the employee. The employee won't have deep pockets, obviously, as the company will. The company's vicariously liable for their conduct. In other words, you can sue the company for what they did if they didn't take action to stop it. But the employee should be singled out. They should be made to feel uncomfortable, and they should learn a lesson. Everybody who hears about it should learn a lesson. They won't likely do it again. If it's social media posts, then again, it depends on whether the posts are something that are objectively anti-Semitic. And there's a difference between simply mourning the loss of lives in Gaza and being in a generic way pro-Palestinian and being anti-Semitic, or cackling over the deaths of Jews in Gaza, or blaming it on Jews or comments conflating the IDF's activities with all Jews. I'm just giving you many examples of things that are obviously anti-Semitic. And if they're posting things like that, you've got a human rights complaint saying this person who works in our place is doing this, and this is making me uncomfortable as a member of that community. I want it stopped. And again, same recourse. Reach a certain point, it might be constructive dismissal action, occupational health and safety application, any of the other remedies I've talked about earlier, and certainly a human rights action. If you want to stay, if you don't want to leave, well, do your best to lobby. At some point, you may feel you have to leave.
So that suggests a couple of questions as a follow-up, because I recall when I was an employer, we were advised by legal counsel that if someone committed something that was an offense, could have been something as serious as a fraud or something more minor, but it was against company policy, we were encouraged to let everyone in the company know something had been done. In other words, for the company to have integrity, to show compliance with its own policies, it needed to tell people what had happened. So here's my question. Is there any concern with breach of privacy if a company says, we're disciplining so-and-so for their anti-Semitic comments or behaviors, or is that inappropriate?
Well, it depends on the circumstance. What if you get it wrong and you've just libeled that person to everybody?
Well, that's why I'm asking, because it could be that people might take it to mean something more than it is, but at the same time,
I don't know why you have to tell the world in any event.
Okay.
Just because it's bad HR. Who wants to work for a company if you do anything wrong, the whole company's going to hear about it. It becomes a massive gossip cesspool. I mean, that's not a company I'd want to work for. So for just HR principles, I wouldn't do that. But there's also the issue of libel, or depending on how it's distributed, or slander. If you get it wrong and you say things that aren't accurate, generally one's allowed to say things that are accurate. But why would you, as opposed to just disciplining the employee in question? Look, in any company, in any area, if someone misconducts themselves, what company ever announces to every employee this person's misconducted themselves, they're being disciplined? Why would you do that? It's foolish.
So it isn't done just to reinforce the policy.
You can reinforce. Those who need to know would know. Those who complained, but you enunciate the policy, or you can say at some point, the following has occurred in the company, and don't identify who it was. And I'm just reminding everyone this is intolerable and you will be disciplined if you do it. But you don't have to say,
right,
Bernie Smith did the following on this day. That's just humiliating.
Right.
And not a great HR practice.
You talked about something I hadn't thought of before when you said the workplace includes social media. So should most companies, or do most companies now have a social media policy that would make it clear to people before they did such postings that it was?
Most companies do, or at least most medium and large companies do. And those that don't should, and those that are small should. Yeah, most companies these days have social media policies.
Okay. Can you speak about the university professors who we see almost leading the way with the worst examples of anti-Semitism? What standards should apply? We don't see university administrations, other than the three, presidents in the US, we don't see university administrations saying or doing much about anti-Semitism within the university environment.
Well, if you read my columns, as you do, you'll see that I took one Osgoode Hall law professor to task fairly aggressively in a recent column, which was most of my column, pointing out, reposting his retweets and asking the question about what Jewish student could be comfortable thinking they might be objectively graded or taking classes from him. And the Post ran it. So I've been, interestingly, I first submitted my column. The Post came back to me and said, we've got to give him a chance to respond. So I wrote to him with these tough questions, and he, I thought, idiotically responded. And I thought his response did more damage to him than my initial complaint. But interestingly enough, in responding, he copied the Faculty Association, fair enough, union member, they'll protect him, I guess, the dean and the associate dean. So he brought my concerns directly to their attention. And then when I wrote back to him again, copying the same people, I was very cognizant who would be reading it. Do I think university administrations have done enough disciplining their instructors or students on code of conduct issues? Obviously not. Could they? They could. Are they protected? Is racism protected by freedom of speech or tenure? No.
I was going to ask you about protected speech in the workplace, whether there's such a thing.
Well, really, there isn't. Let's start with that. Obviously, racist speech is prohibited by the Human Rights Commission, which becomes part of the policy of every company by incorporation of law. But quite apart from that, there's no freedom of speech in the workplace. Employers largely have the right to dictate how and to what extent there's going to be free discussion on issues. And there's no right to free speech in workplaces.
Given that you've worked with major corporations, can you talk about any examples that you have known about even that where companies adopted the IHRA? Because the position CAEF has taken is that if more organizations such as universities and school boards both adopted and acted on, implemented it, we would be given tools to deal with anti-Semitism.
I don't know of any companies adopted it.
Was that something you think is worth pursuing?
I hadn't even thought of it till the second, because I've always put the focus on that was getting governments to adopt it rather than individual companies to adopt it.
Well, and governments have, but it doesn't appear that they've done much to create an environment that implements it.
Well, some governments have, some haven't, but that's, I thought, has been the primary struggle because that's more important than the law flows from that.
Yeah.
Yeah, it would be helpful if companies did, but I don't think it would have the same impact as governments doing it because there's already human rights legislation in every province and federally. So we already have protection against racism and anti-Semitism and poison work environments based on your religion or race or creed. It's already in existence in the law.
So I've noticed the work that we've done at CAEF is that professional associations, teachers, and social work organizations have anti-racism policies. Very clearly, as you said, nobody accepts racism, but the way it's worded, it's anti-Black racism policies. When we ask that they have an anti-Semitism policy, they back away. None of those organizations actually have a statement to protect Jews as they do to protect people of color.
Well, that was really the first part of my remarks today, talking about DEI and its emphasis on pitting race against race based on color, rather than protecting actually the most discriminated against, which is why I started the talk with those statistics, which are shocking and are even worse today. Yes, you're right, but I think that now you'll have a more fertile environment than you had 4 months ago for having companies adopt that. Because now anti-Semitism is so much in the mainstream and in the mainstream discussion that everyone has to be more receptive to that argument they were 4 months ago. Anti-Semitism was dismissed as insignificant. No one knew these statistics I cited, and no one really cared. Now they can't hide from it. So now is the time to get those changes made. And I'm going to add to that, the Islamic radicals have not done themselves any favors. They're parading around the streets, canceling Christmas, stopping major intersections, acting so demonically, has not endeared them to the citizenry. And the more they do this, the more people and Canadians are pitted against them. Mm-hmm. I think that's part of why the chief of police and Myron Demko in Toronto and others have taken stronger positions because they're reacting to public sentiment, which is increasingly going our way.
That's a good thing. I'm going to read you a question that has been submitted by somebody attending. It's a bit detailed. As they're retired, they worked for a mid-sized Canadian subsidiary of a US company, and his former employer refused to pay him if he did not work during the Jewish high holidays. He looked into it, found the Canadian Supreme Court ruled in favor of payment, but the Ontario Human Rights Commission did not. He went back to management, argued the OHRC did not overrule the Supreme Court. Now he wasn't paid. What steps should he have taken or could still take?
Well, I'm gathering he didn't file a human rights complaint. If he did, he'd win.
Uh-huh.
Yeah, you don't pay someone for not working, but the employer is required to let them not work and give them a substitute day instead. That's what the law is.
Okay.
So I don't know what happened here and exactly the circumstance. You're giving limited information in the question you're given to ask, but the answer is employers are required to accommodate religion. And now people can't play the game of saying I'm religious, I'm Jewish, and therefore I can't work on whatever the day is. If that's not actually, if it's someone like me who's not religious, and has been known to go to synagogue, not to synagogue, but to work on Yom Kippur, if they found that out and I made that argument, it would be a scam and they wouldn't have to honor it. But if the person could establish, or if the employer couldn't establish they weren't honestly religious, then the employer has to accommodate that. But they don't have to accommodate that just by paying them.
Right.
They have to accommodate that by either paying them or giving them alternate hours to work to come in on a Saturday instead, or whatever the case may be.
Thank you. I think a lot of people are curious as to what is going to come from the investigation of the 74 students at TMU. Do you have any further information as to what is taking place and where that's headed or what the outcome might be?
I think Ryerson or TMU's handling of it has been atrocious from beginning to the end, with the 700 lawyers and law clerks and people who they say were in the legal community, but many of them weren't. There was political science professors, et cetera, signed a letter supporting the TMU students. My next column in the National Post said I've just added 700 more names to my never hire list. So, and there was a lot of other of us who did the same thing. What will come of it? I don't know this judge. I don't know what instructions he's been given. Because he's a judge, he's probably not being leaned on too hard. But I don't know. I know B'nai B'rith called for their immediate expulsion. Now, they couldn't do that legally because they have a right to a process of stating their case. They can't just be automatically expelled, but B'nai B'rith didn't know that, I presume. But I think they should be disciplined. I think the law study shouldn't have to be called to the bar. But that's my view. Maybe they put off suspended for a year. But what will TMU do? I don't have any more insight than anybody else does.
It looked like TMU really just kicked it down the road.
That's right. They just called an investigation after being calumniated and attacked. And lots of people have drawn money. And here's the real tragedy. Students who did not sign that petition were entirely innocent, who may even been on our side of the debate. But even not on our side of the debate, simply not having signed the petition, they went to that law school in good faith. And now no one wants to hire them because half of those signatures were anonymous. So you don't really know who signed and who didn't sign. So now there's a stigma on the entire student body. And they're furious, the other students, because of that. It's damaged their career prospects. Now, what I do and what the Attorney General of Ontario has done, when any TMU students interviewed, you ask, did you sign that petition? First of all, you check the names, but if there's a lot that are anonymous, as I said, so did you sign that petition? If I said, no, I didn't, you then say, and again, not only do I do this, but the AG has done this. If we ever find out that you lied and you did sign the petition, it's cause for that lie is cause for discharge as soon as we find out. So they're really in a pickle. But every TMU student's being asked that question. A pretty embarrassing, uncomfortable way, discomforting way to start your legal career. I
think some people also were going to pull their funding. Donors were going to pull their funding.
Some have, yes. Some have threatened to, and some already have.
Right.
Some have refused to teach there.
There is a petition that I saw this morning, and maybe some of our American viewers might be aware of this. The young woman who gave the Victorian speech at CUNY University, which was horribly anti-Semitic, is now up for what? Legal convocation. She is to appear before the bar to be certified in New York, and there's a petition since she's graduated from the university, asking that she never be awarded her license to practice. Is that an appropriate response? And that's something could be done here, for example?
It should have started 2 months ago when the petition came out. But the question is, what battles do you put your energy into?
Mm-hmm.
I get requests all the time, obviously for free assistance of one form or another in this battle, because I'm so publicly associated with the battle now. And sometimes just say, I've got my particular, there's a couple of things I'm working on that I can't discuss, but that I think will have a tremendous impact in stopping the anti-Semitism of the street. If me and a few others are working on confidentially. But there's only so many things you put your energy into. Is that something you're going to put your energy, that particular petition? I don't know. I think to a large degree, the TMU thing has moved to the stage of the judge looking into it until we see what the judge recommends or what they do. I don't know. I don't know that a petition is going to influence the judge very much. So I'd want to wait until that. But which battle do you pick? The question.
There are so many.
Yeah.
Can you talk a little bit about one of the battles with the unions? You're aware, I'm sure, that many of the unions, particularly government sector unions, have supported resolutions in the past to support BDS, which is itself pretty anti-Semitic. And individuals have tried to opt out of unions, not pay their dues because they don't support that and they have no choice. Is that going to change? Is there anything a union member can do?
Well, there's lots a union member can do, but not paying dues is not an option. I won't bore everybody with the details of the Labor Relations Act, but the only time that someone can not fund a union or not pay dues to a union is in the first term of a first collective agreement. If the union got in during, when the employee was there was no union, then they got unionized. So just for that first term, not people who came to a company that was already unionized. And it has to be on a grounds of religion, that your religion, and Judaism doesn't qualify, prohibits you from joining any union, not the particular union in question. So forget about not paying dues. You can do all the things I talked about earlier, try and take over the executive, try and decertify, file a human rights complaint, and sue them, as our firm is suing CUPE, the biggest national public sector union. And its
Right.
president.
Well, we're happy to hear that. You're probably also familiar with the situation at Sick Kids Hospital, in which an anesthesiologist, I'm not saying that right, posted hateful remarks after October 7th. And the hospital agreed to mount an investigation, which sounds like another way of not dealing with it right away. Are you familiar with this case, and what are the hospital's remedies if they were really going to do something?
I don't know anything about the case.
Okay. I understand that in a number of situations, Jewish doctors have been pilloried by their colleagues, which is unbelievable. And I was recently contacted by a new organization called the Jewish Medical Association. Doctors, I think, are finding that they're being, their social media posts against them if it's known that they're Jews or support Israel. So what should professional bodies do?
Professional bodies as opposed to doctors themselves. I mean,
Well, there's a medical association, just like there's teachers associations, and they don't seem to be standing up for their members.
Generally, they're not our friends. So look what happened to Jordan Peterson, for example. The ruling came out yesterday from the Court of Appeal, supporting the divisional court ruling that he could be disciplined by his professional body for political comments he made on Twitter that had nothing to do with his professional psychology. So don't put a lot of confidence in professional bodies. What can individual members of the profession do? They can do what members of unions can do, try and get elected to those professional bodies where they will have some influence and set the direction of that professional body. And more specifically, if you're working for a hospital, whether it's Sick Kids or someone else where anti-Semitism is prevalent, it's just another employer. There's no distinction. File a human rights complain, file a lawsuit, lobby, do all the things I've been talking about throughout the last hour.
Okay. Howard, I want to thank you very much for your time. I want to encourage you to keep writing. I'm enjoying your articles and I'm sharing them as widely as possible. And I think that this is a sort of a niche topic that we haven't considered before, dealing with anti-Semitism in the workplace. So I really appreciate that you have really stood out and stood up against the Jew haters in this environment, in this arena. And thank you everyone for joining us today. I wish you all well this afternoon or evening, wherever you are. And our next webinar will be January 25th at 1 p.m. We'll be examining the systemic anti-Semitism in the United Nations. Two experts will talk about all the various institutions, organs, commissions, and committees, councils, etc. of the UN that are all against Israel. So please join us then. And good afternoon, everyone.
Thank you, Andrea.
Thank you.